let's take a look at the types of pension plans. Under ERISA, pension plans are categorized as either defined benefit or defined contribution plans. Legal requirements vary depending on the type of plan, with defined benefits plans being more closely regulated. As the name suggests, defined benefit plans promise a specific pension benefit on retirement. The size of an individual's pension is typically determined by a formula based on years of service and earnings. In establishing a defined benefit plan, an employer undertakes a long-term obligation to provide a specified level of retirement income to its employees. A pension fund is maintained separate from the employer's other assets, and benefits are paid from the fund. Obviously, adequate financing is the key to the operation of a defined benefit plan. In cases where an employer with a defined benefit pension plan is unable to meet its obligations to retirees, the Pension Benefit Guaranty Corporation intervenes. Employers with a defined benefit plan pay termination insurance, and these funds are used to pay the PBGC to provide at least partial retirement benefits to retirees and vested employees. The many types of defined contribution plans include 401ks, profit-sharing plans, stock bonus plans, and employee stock ownership plans known as ESOPs. In all of these plans, contributions are made into individual employee accounts. The funds in these accounts are portable, so they can be moved to other retirement plans when employees change jobs. The pension benefit that employees receive is not specified beforehand and depends instead on the amounts of these individual has in a retirement account at the time of retirement. In turn, those amounts are linked to choices about how much income to defer, whether employee contributions are matched by their employers, which investments are selected, and what gains or losses are from those investments. Thus, with defined contribution plans, employers establish plans and define what their own contributions, if any, will be. They make no commitments regarding eventual payout to employees. Policymakers have become to respond to the reality of a pension system in which defined contribution plans are the norm. The Sarbanes-Oxley Act requires that employees receive 30-day notice of blackout periods that would affect their ability to direct investments or receive contributions from their 401k. The law provides that corporate insiders will also be subject to any blackout periods, meaning that they will be unable to sell shares or exercise stock options when employees with 401ks are so restricted. While defined contribution plans are not governed by the extensive funding and administrative requirements, employers and other decision makers still have a basic fiduciary duty towards participants in defined contribution plans. Employers should do a few basic things regarding 401ks and other defined contribution plans. First, employers must invest the funds deducted from employees' pay no later than 15 business days after the end of the month in which deductions are made. Second, employers should carefully research investments, offer a wide range of types and companies to choose from, and warn employees regarding the dangers of inadequate diversification. Third, employers should provide regular opportunities for employees to divest themselves of company stock and place those funds in other investments. Fourth, employers should make impartial investment information available to employees. Fifth, employers should consider placing responsible or reasonable limits on the extent to which employee accounts compromise company stock and should remove company stock as an investment option when it's no longer a prudent investment. Finally, employers must not violate their fiduciary duty to manage plans in the best interest of employees while imposing lockdowns for illegitimate purposes.